Chief Judge, how am I on time?
You have about 7 minutes.
Okay. A little bit further on that, then I would also point out that Mr. Sutton deposed several of the State Bar's Phase 2 witnesses, so he clearly had notice and understanding of what evidence the State Bar intended to present.
Let me ask you about the administrative fees that were assessed. I think it was $35,000.
Yes, sir.
In your brief, you cite to 84-34.2, which allows administrative fees, and you reference the fact that the bar had promulgated a schedule of fees. I don't think you provided us a copy of that. Where would we find that?
Gosh, where would be found at the moment? I believe it's on the State Bar's website, although we have a new website, so I don't want to promise the content of that. But it is something that defendants are notified of by the Disciplinary Hearing Commission. And I don't know if you had an opportunity to review some of the content of Mr. Sutton's supplemental authorities that he submitted on Friday, but what you see there is even when a lawyer is issued written discipline, there is notice provided that these are the administrative fees that will be assessed for this. If you choose to reject the written discipline and go to the DHC, that the administrative fees will be thus. So that there is notice provided to litigants about that. I'm just not aware where it is published right at this moment. Nothing in the State Bar statute specifies any particular process for publication. However, the lawyers who are subject to disciplinary proceedings are absolutely advised of these fees. I would like to talk briefly about the argument about the constitutionality of the State Bar and the Disciplinary Hearing Commission. I think it's important, as I mentioned earlier, to distinguish these two entities, one being a regulatory agency, the State Bar, and the other being a quasi-judicial agency, the Hearing Commission, and they do operate independently. In the brief, Mr. Sutton contended that certain sections of the Constitution actually precluded this arrangement, in that the DHC was not allocated to any of the executive branch departments. That's simply not what the Constitution says, as indicated in our brief. And I would also like to respond to some of what has been said about the dental board case. The dental board case was an antitrust litigation. The sole issue there was whether the North Carolina Dental Board was entitled to state immunity under the Parker Doctrine when suit was brought against it for antitrust under the Sherman Act. That really has no bearing on this case, and certainly does not stand for the proposition that the Dental Board is not a legitimate state agency, that it acted ultra vires, none of that. It was a very narrow issue. And so, although it may include some of the same language that Mr. Sutton uses in these arguments, it doesn't actually apply in any way. With respect to the argument about separation of powers, I don't believe that there is any suggestion that the DHC's quasi-judicial exercise of power in this scenario infringes on the judiciary. And in fact, repeated decisions from this court and the Supreme Court either tacitly or expressly approve the scenario in which this administrative agency exercises that quasi-judicial power. It has not been ever determined by a court to be an infringement on the judicial branch. And furthermore, the DHC is not controlled by the legislature or the executive, so it could not be an infringement by another branch of government on the judicial powers. Unless the court has additional questions, I think that's all I have. Thank you. The North Carolina State Bar would ask this court to affirm the DHC's order suspending the appellant's law license. Thank you.
Thank you. Rebuttal, sir?
This is the document and all the explanation that came with it. Well, it's $35,000. So if they were reason they can do that is why the dental board case was cited. Counsel was quite correct. The United States Supreme Court was not litigating the constitutionality of the North Carolina Dental Board. They were litigating whether it was a state agency, a true state agency, entitled to exemption from the Sherman Antitrust Act as true state agencies are. It wasn't concerned, it's North Carolina's business, whether the dental board complies and comports with the Constitution. What I am saying is that the same rationale, both the dental board and the bar suffer from the same malady. They have no supervision. No one can tell them. If what I listened to the bar saying a while ago is that the same thing that order says. Well, Mr. Sutton could petition to the court, and Mr. Sutton could petition to Wake, but if he didn't win, that's his fault, not ours. So it's not our duty to see that he has due process. It is their duty to see that everyone who comes before it receives due process.
What was the outcome of your lawsuit in Wake County? Was it a 12B6 dismissal?
It was dismissed on 12B6 without reason. It just says dismissed due to 12B6, so I don't believe collateral estoppel could ever be an issue in that. And because I don't know why the court granted it.
Was an appeal perfected?
The appeal was not perfected, but without any factual findings, there can't be any collateral estoppel. And for all I know, he thought that it wasn't ripe for an injunction, so he said, I'm not going to pay any attention to the First Amendment right. He certainly didn't take evidence on it.
Was that the only request for relief? Was it an injunction?
No, there was injunction, declaratory relief as well in the Wake County action. And
But the merits were not reached.
It just didn't reach them. Didn't reach any of it.
Well, you're saying it was a 12B6 order without findings of fact, as is usually the case on a 12B6 order, but that doesn't mean the merits weren't reached. It was a dismissal on the merits.
It wasn't a dismissal on the merits. For all I know, he said a cause of action wasn't properly stated. I don't believe, with all due respect, Your Honor, that's a dismissal on the merits. That may be, as counsel said, a pleading error. He didn't specify why. And counsel said something I want to address before I step down, is that the appellant misapprehends the Constitution. The Constitution of North Carolina is very clear. In one of the cases cited in the brief, I believe it's Dumont, but it could be another one. I'm not 100% sure. It explains how we had the 1970 Constitution. It came from the 1968 Commission, and they reorganized government. And after they did that, in the Constitution, they had Article 3, Section 11, that says every administrative agency has to be allocated. It does say there are some bodies that need not be allocated, but in Article 4 on the judiciary, it says only administrative agencies may have judicial functions. If the bar doesn't want to be allocated, that's fine. But as they say, they're not in the executive branch, and there's no provision for any agency in the state of North Carolina that is not in the administrative branch of government to exercise any judicial power. They say they act from the state of North Carolina, but I defy the bar, and they haven't today, said, here's where we are in the Constitution. In closing, I would like to say to the court that I would ask to vacate this. They're without jurisdiction, they act extra-jurisdictionally. They don't have jurisdiction, so there's no point to remand it. When they had the opportunity to make findings and conclusions, they didn't do so. There's not a single word of speech or freedom of First Amendment in a 35-page single-spaced order, and they shouldn't get a chance to do it again. This case does, to a certain extent, hinge on society and civilization because we have that contract, the Constitution. The bar is required to follow it, and we're entitled to receive the benefits of it. In this case, the bar essentially said, it's not our problem that his license is taken, and nobody has yet said how the First Amendment rules or not. Thank you.
Thank you. Appreciate both of your arguments.